All right, good morning, everyone. This is Dave Grosskloss at Dorsey & Whitney. Thank you all for joining us this morning, still in Central Time. I'm happy to say we have folks, I believe, on the phone taking part in this webinar from across the country, so we're very happy about that. I'm going to take care of just a few housekeeping matters here to start. First of all, with regard to questions, for those of you that may have printed off materials from prior distributions, James Smith is unable to join us this morning, and so questions can be emailed to my email address. I'll provide that to you here quickly. It's Grosskloss, Grosskklaus, .david@dorsey.com. Unfortunately, you'll see on the next page, the presenters today were supposed to be myself, James, and John Danos. Unfortunately, Mr. Danos is sick this morning. Mr. Smith was caught in some weather problems just north of the Iowa border, so he's not able to join us this morning. So everybody has me flying solo this morning, and I hope not to hear a lot of hang-ups as a result of that. A couple items that we wanted to talk about with respect to the agenda and what we're trying to cover today. Let me just, by way of introduction, first we're going to try and hit on some disclosure basics. Just for everybody on the phone, we've got a large audience, very diverse audience on the phone, some issuers who are clearly annual issuers or issuers who issue in the municipal world on multiple occasions each year. We have some very infrequent issuers who might only be issuing once every several years. We do have some very large issuing entities on the phone. We also have some very small issuing entities. And lastly, we have some issuers who, because of the nature of their industry, whether that be healthcare, assisted living, or what have you, they may have very sophisticated disclosure policies driven by continuing disclosure agreements and industry standard measurements that require them to provide disclosure on a much more updated basis, whether that be quarterly, semi-annually, or what have you. We have some issuers who obviously aren't required to provide annual information on nearly as rapid a basis as others. So that's kind of the context overall as we try to work our way through the agenda. As I started to say, we're going to touch and hit disclosure basics. We're going to point out some of the overarching laws with regard to governing disclosure. We're going to touch on two new rules that become effective that were just added to 15C212. Those become effective here coming up in a couple weeks on February 27th. We're going to talk a little bit about policies and procedures, talk about how that dovetails with the other items. Then I will try to leave some room for questions and answers. We do have a fair amount to cover today. And as we go into this, you'll see for some of the new amendments and some of the questions that have been raised over the last several months amongst a number of organizations, some of the questions may be a little hard to answer, but we'll try to put them in some context for everyone. So let's first, as we dive in here, let's outline some glossary of terms you're going to hear me use. First of all, kind of the parties to a transaction. For some, this is fairly basic, but I do want to walk through it quickly just so people understand my use of certain terminology. Issuers, certainly the governmental entities that actually issue the bonds. I'm going to put in that category as well. You might hear me refer to borrowers. So in context of healthcare, nonprofits, certain other entities that may be in the realm of issuing municipal debt, they fall into the role for disclosure of needing and being required to comply, but they aren't the actual issuer of the debt. They're the obligated party, I think might be the best reference to those types of entities. Underwriters, they're the folks that you all work with that go out and sell your bonds in the marketplace, and ultimately they're in the role of finding buyers for your bonds. The next group, municipal advisors, they are now regulated entities. Historically, you would hear them referred to as financial advisors. They are one and the same. I just prefer to use the definition of municipal advisor since that is by regulation the terminology that's used. The SEC is the Federal Securities and Exchange Commission. More about them later. They are the entity ultimately that issues the rules by which underwriters are bound. We'll get into a little more of that distinction here later. They are also the entity that provides regulation and rules with regard to muni advisors. Some documents I'll refer to: an OS, an official statement. That is an offering document when an issuer or borrower is going out into the market with the issuance of bonds. A CDC or a CDA, that's a continuing disclosure certificate or agreement, one and the same document. In a couple pages here, we'll show you just by cover page what those documents look like. Next, a dissemination agent agreement. So this is an agreement whereby many parties have entered into a contractual arrangement so that their financial information or continuing disclosure information, they have contracted with a third-party entity to actually download that information onto the EMMA system. EMMA is, I'll just briefly touch on it separately, EMMA is the electronic portal now for all disclosure with respect to municipal obligations. For those of you who have never taken a look from the issuer perspective at the EMMA website, I urge you to go to that website, take a look at the materials that may have been filed with respect to your organization on EMMA. EMMA is, in the municipal world, what would be the comparable electronic information portal to the corporate world, which would be EDGAR. One thing I do want to mention with regard to dissemination agent agreements, while issuers may have entered into agreements for the provision of putting their financial information onto EMMA, the dissemination agent agreement does not mean that the issuer is not duty-bound and responsible to make sure that the information that gets put on EMMA is compliant with their continuing disclosure agreement. So for all you folks out there, especially in the government world, just understand that while yes, you may have an entity contractually putting the information on EMMA, you are ultimately responsible as the issuing entity for making sure the information that gets put on EMMA is compliant with your continuing disclosure agreement. I think sometimes that may get lost just a little bit in the mix. So next page, just very briefly, that shows you what an OS is. That's a cover page to an offering document. And the next page is simply what a continuing disclosure certificate looks like. Again, certificate agreement, it's simply nomenclature. It's a contractual document and how it's referenced by name, all operating in the same fashion. So next I want to just talk a little bit, and hopefully as we go through this presentation, this will start to become a little more clear And as we get into some of these amendments new amendments with regard to 15C212, I'm hoping everybody will start to optically see now what is going on in the municipal world. Who knew that now the roles of public finance lawyers would start to become even more focused, but certainly the folks you're dealing with, certainly from the counsel role and in other perspectives, there are certain different rules now that you all have to be aware of, and that kind of, I think, is fairly self-evident when you break down the roles of both bond counsel and disclosure counsel. So probably the most easy way, I think, to display or think of bond counsel is think of tax and state law issues, and think of your regulatory entity in that case as the Internal Revenue Service. So bond counsel prepares all the documents, they work through due diligence. You'll hear reference to due diligence, and now I'm talking about tax due diligence. Bond counsel prepares usually all the resolutions, the bulk of the financing documents for an issuance. Again, generally to be evident of compliance with Internal Revenue Code rules in the IRS to make sure the bonds are tax exempt, and secondarily to make sure that state law provisions are being complied with for the issuance of the bonds, ultimately to be giving opinions again along lines with tax exemption and state law compliance. Disclosure counsel, on the other hand, and I think the easiest way to think of disclosure counsel is focused on matters with regard to securities law. For the most part, in the municipal setting, that is almost always going to be federal securities law, occasionally maybe a state securities law matter, but probably not because of certain exemptions I won't get into. And the regulatory entity, well, again, because of the Tower Amendment, which I'll allude to later, but ultimately now through 15C212, the regulatory entity that disclosure counsel is focused on would be the Securities and Exchange Commission, the SEC. So, disclosure counsel, what are they actually doing? Well, they're working on the matters we're going to talk about today. They're also going through due diligence, but their due diligence is much more focused on securities law matters. They're usually preparing, or they are preparing, the offering document, the OS, because that's the marketing document of the bonds, and that's the document that is most germane with regard to SEC matters. Then as well, disclosure counsel is advising on matters with respect to continuing disclosure, so on and so forth, making sure that offering documents, and now to some extent continuing disclosure, is operating within the concept of materiality, omissions of fact, material misstatements of fact under 10b-5, and so on and so forth. So at the very high forest versus trees level, think of disclosure counsel in the securities realm and bond counsel in the tax IRS realm. So with that as our framework, let's talk a little bit about some relevant laws with regard to the securities side of municipal financings. At a broad level, the Securities and Exchange Act of 33 and the 34 Act are the broad framework. Within that framework, the substance of violations for municipal issuers emanates from Rule 10b-5, which is something you'll often hear us refer to when we talk about disclosure. Rule 10b-5 is the direct methodology by which municipal issuers must comply. Think of 10b-5, and you see there the statement that is the Rule 10b-5, no false statement or omission of material facts with regard to the sale purchase of municipal securities. This is, in essence, fraud. This has been in place for, 90 years? This is not new to anybody. These are the types of discussions we have when an entity is issuing municipal securities in the market. In other words, you're doing a new issuance, a refunding, or something of that sort. I'll get into a little bit later the interplay here now that I would articulate, I think, is occurring with the new rule amendments under 15C212. So, SEC and others have direct regulatory authority with regard to municipal issuers under 10b-5. However, there is a Tower Amendment which disallows the SEC from directly regulating municipal issuers. So, that's where Rule 15C212 comes in. Technically, the SEC is not regulating through 15C212 issuers. The SEC is regulating underwriters. 15C212 applies to the underwriters, the folks that buy your bonds. So, how is then, and why are we so concerned about Rule 15C212? Well, as part of 15C212, underwriters must ensure themselves that issuers will be compliant with certain rules and regulations, and that compliance is undertaken contractually through your continuing disclosure agreements or certificates. So, as you can see, the use of 15C212 has really now become the regulatory mechanism for the issuer to reach through to through the underwriters to oversee issuers contractually. I would articulate that with these two new amendments that we'll talk about here in a minute, Amendment 15 and 16, practically there's a pretty significant erosion of the Tower Amendment, I would argue. That's a theoretical discussion. We won't go any further with that. So, anti-fraud rules, again, just to focus a little more on what it means to be a false, misleading statement of material fact, including omissions. We'll talk a little bit more about this when we break down new amendments 15 and 16. So first of all, we're talking about statements. This includes information provided to investors or potential investors. In the analysis, you have to presume that investors are all the way from incredibly sophisticated to what I refer to as moms and pops and uncles and aunts and so on and so forth. So we cannot take the presumption in our analysis of 10b-5 that we're only dealing with very, very sophisticated entities. An example with respect to this, the city of Harrisburg, where the city was charged with security frauds after making some misleading and incomplete statements with regard to their financial condition. So, this is also an example where the SEC has really broadened its scope. I would say historically, up until maybe 5, 6, 7 years ago, SEC involvement and enforcement of 10b-5 was really not invoked unless and until there was an actual default. So bondholders now suddenly are not being paid as a result of default. That, of course, causes investors not to be happy, and that would usually invoke much more review by the SEC. Harrisburg, just briefly, is one of those cases where the SEC is now taking enforcement action under 10b-5 without a default even occurring. What they are saying is, you public official made a statement, that statement really was misleading and it wasn't complete as to your financial condition, of your city, and so we're going to take action because we deem that to be overall misleading. You can see here, and I'll come back to this again, new Amendment 15 under 15C212 is really focused on materiality. I would submit to you that a lot of the questions with regard to 15 revolve around wanting or expecting the SEC to tell us what materiality is. I would submit that's not going to happen, and here's a little bit of the reason why. Under 10b-5, again, for many, many years through court cases, the definition of materiality has been honed a little bit as best it can be. You can see in Northway, and as you read through the release for the new 15C212 amendments, these cases are alluded to with regard to determining materiality. So, as you can see in TSC Industries, materiality definition stated as the substantial likelihood that the disclosure of the omitted fact would have been viewed by the reasonable investor as having significantly altered the total mix of information made available. Folks, this is where I think due diligence comes very much into play. We're not just talking about misstatements of fact. Those are usually much more easy to identify for all of us as we go through disclosure matters. And the key for due diligence, I would submit, is not necessarily to root out misstatements of fact. It is to root out what potentially could be omitted. In other words, what is going on in your community at the issuer, what is going on in the healthcare setting at a borrower level, what information did somebody not recognize might be viewed by an investor as having altered the total mix of information that they're using to decide whether to make an investment in your bonds. Moving on, you can see substantial likelihood under all the circumstances the omitted fact would have assumed actual significance. That's also from TSC. And then you can see from the next case defining or helping to define materiality. It's a balance of indicated probability the event will occur along with the anticipation of its magnitude. So all of these things kind of help generally guide in this determination of materiality, which goes to whether we're going to talk about it or not in offering documents, and now whether we're going to really be talking about it in certain circumstances with regard to continuing disclosures. So, again, just to keep in mind, it is always the issuer's responsibility. Yes, of course, you hire professionals to help you with all these things, and yes, of course, ultimately there could be action taken against those professionals. The point here is that it is your responsibility, I would argue, maybe not to get it right in determining is something material, but it is your responsibility to get it right to make sure the professionals know all of the information about you as you're issuing debt. Again, I can't stress enough that really is the entire point of due diligence. The other thing, just to point it out, that the case law and SEC actions, there have now been a number of cases where personal liability has been imposed upon public officials. It's been imposed on the governing body itself. It's been imposed on employees, whether that be financial officers, so on and so forth, and again, elected officials. I point that out only to point out two things. Number one, certainly over the past number of years, it is the SEC that has been far more robust in enforcement of municipal entities, much more, I would submit, than the IRS. And most importantly, the SEC is now really much more focused on prevention by making examples of public officials and or officials, staff at public officials, if they believe that folks are not being compliant with rules of 10b-5 and so on. Of course, underwriters and all of us as professionals also can be liable. That's, again, where due diligence comes into play. And then lastly, just to point out some of the consequences of fraud allegations, we are talking about fines, significant fines, both individually and to the organization. We're talking, these are criminal matters, so there has been jail time with regard to certain public officials, certainly financial penalties, civil fines, so on and so forth. And then, of course, at an organizational level, there is reputational risk with regard to, can the organization go back out and issue debt? Will entities loan money? Will there be interest rate increases because the public is less likely to purchase that debt? Next, let's talk just a little bit about the aspects of Rule 15c2-12. And I'm going to start now kind of moving a little faster because we do have a lot to cover. Two aspects of the rule just quickly. So again, going back to these rules, and the SEC is overseeing the underwriter, so the underwriter is, with regard to continuing disclosure, they must determine as part of their regulatory regime that the issuer is agreeing in a continuing disclosure agreement to provide ongoing continuing disclosure. So that's a couple of different things. That's providing annual financial information. That's, if you look at your continuing disclosure agreement or certificate, you'll see provisions or sections as to what annual information you'll be required to provide, whether both through audited financials and operating data, and then material event notices, which are set forth by Rule of 15c2-12. We'll get more into those here in just a minute. Secondly, part of 15c2-12, you must provide, or the underwriter must ensure that the issuer is providing a description of material noncompliance with those continuing disclosure agreements. This, again, part of due diligence you've all been undergoing, where we're looking at a 5-year period to make sure that indeed you have complied with your contract provisions of your continuing disclosure agreements, making sure that that financial information and operating data and so on and so forth, and or any material events are both timely and appropriately disclosed on EMMA. This is rarely occurring. There are certainly instances of exception from 15c2-12 compliance. There you see less than $1 million, certain authorized denominations. I would submit that by and large, because of bank loan scenarios and other things, most of the time, if you're dealing with the underwriting community to borrow money, you're probably not going to be exempt, but there certainly are some exceptions from compliance with 15c2-12. So, more specifically, material events listed, and there you can see new items 15 and 16. I'm going to touch just very briefly. These material events have, for the most part, been around for some number of years. The ones that we see people running into in some regularity with respect to forgetting to list on EMMA when these material events occur. They are rating agency changes. There I would point out a rating upgrade is every bit as much a material event as a rating downgrade. I think usually it's upgrades that people don't recognize. That's number 11. You'll see bond calls. I think sometimes a bond call that is missed on a regular basis. 15 and 16, I want to point out in this context, given the fact of the coloring. So 15 and 16 become new amendments. They become effective, as we said, February 27th. first thing I would point out in this context about new item 15. So now it is the incurrence of a financial obligation. That is a defined term under the new rule. There will be a lot of discussion you'll hear and have your professionals talking about that as we go forward. So it's an incurrence of a financial obligation of the issuer, or it's an agreement to covenant an event of default, remedy, priority right, or similar term. And now, again, you see this caveat, if material. What the SEC, on a broad basis, is trying to capture in a more timely basis would be entering into certain types of financial arrangements, whether that be banking arrangements, a direct loan from a bank. That's probably the easy one. Much more difficult, and we'll get into this a little bit, is what other potential obligations of an issuer might be financial. Now, again, caveated by it must be material. Again, as I stated, we're not going to get a definition of material. That's for you along with your professionals to kind of work your way through whether you think certain things are material. The next item, and we'll break this down a little more, but number 16, defaults, acceleration, terminations, modifications, or similar events under a financial obligation. So there you see that definition again. Then caveated by reflecting financial difficulties. We'll talk a lot more about that, but those are the two new material listed events. Just briefly, while we have them all on the screen, I would submit that I think now number 16 somewhat renders moot some of the prior events with regard to non-payment defaults and unscheduled draws and things of that nature. I don't mean to say moot in terms of they're still material events. I think they're somewhat neutered by the fact that now, because you might be taking action under 16, the timing by which you would be filing an event under 16 would probably be necessary to be filed well before you now get to non-payments and so on and so forth. The trap, I think, for everyone will be you may have disclosed it under 16. However, then when the event occurs under 2, 3, 4, or something of that nature, I think you will be required to now disclose it again. So just a nuance in the rule. Next slide, material noncompliance. So the issuer again must describe in the OS material noncompliance with prior continuing disclosure obligations. Reporting is required if those events again occurred within the last 5 years. This is a statutory of limitations provision. And I think most folks now, because of the MCDC initiative by the SEC several years ago, what we're talking about here in the OS are these statements with regard to your failures of compliance over the last 5 years, or hopefully the ability to state that there has not been a failure of compliance with regard to any prior undertakings under the rule. We'll kind of just quickly run through this because I want to move on to some other things. You can see here, next slides are the relationship to the Antifraud Rules. Again, a little more discussion of material noncompliance. For those of the folks in the room for which this is related to ongoing annual training, I want to just quickly move to the heightened attention to disclosure, again, just to make infinitely clear what the trend has been with the SEC. As you can see, there's been a significant transition by the SEC into active regulation for issuers, and that really goes to not waiting necessarily for there to be a default of payment. The SEC has been strongly enforcing continuing disclosure compliance. For those of you who have been around prior to 3 or 4 years ago, the MCDC initiative certainly was the one of the best indicators of that, and also the rulemaking has been much more robust. That's why you see new amended rules 15 and 16 to address bank loans and direct placements. Again, when you look at the definition of financial obligation, has now become much more even broader than that, those limited purposes. As recently as December and January, new chair of the SEC, Clayton, has made very serious remarks about any number of disclosure matters. The municipal world right now is a significant focus of the SEC. They are upset significantly about 2 things, I would say. Number one is the transparency of the totality of information that's being provided, and more specifically, there's quite a bit of concern at the timeliness of being required to provide that information to the market. So, motivating factors you see here, the municipal market is a multiple, I think it's a roughly $3 trillion industry now. There's also a much more greater recognition that investors, where they used to be buying perhaps municipal bonds to hold them through maturity for 20 years, that certainly is no longer the case now because of risk tolerance and all kinds of other reasons. You folks in the municipal world, your bonds are traded equally as Amazon stock and all kinds of things. There are mutual funds specific to the muni world, and the point being, at least from the SEC's perspective, is they see no reason why municipal bond market should be treated any differently than the corporate world. Similarly, there have been some much more high-profile bankruptcies in the municipal world. Puerto Rico is a standout, the city of Detroit several years ago. And so you also now do, on a national basis, have some financial crises, defaults in payment to municipal bondholders, and so on and so forth, which just caused the SEC to raise their scrutiny that much more. Very quickly, I'll let folks take a look at on their own the items with regard to SEC enforcements. As I've stated, MCDC certainly, if nothing else in the continuing disclosure world, left an indelible mark for the underwriters that we all deal with. It left at least a $500,000 indelible mark on their balance sheets. And so that's why there were not, as a result of MCDC, any issuers that paid fines. Certainly some issuers who filed under MCDC were required to accept that they had been negligent with regard to their continuing disclosure agreements and so on and so forth, and had to agree that they had undertaken securities fraud. Having said that, again, issuers weren't financially penalized yet, but I would submit to you that there were certain bodies that we all deal with that were financially penalized, and that's why this is an ever serious topic. There you can see more specifically some of Chair Clayton's remarks. I won't touch any more on those. I would suggest everybody take a look at Ramapo, which was a recent decision. This was with respect to, I'll touch on this very quickly, the town of Ramapo. I think the key takeaways, there were some pretty significant bad acts. This was clear fraud. There were some agreements, fraudulent agreements, cooking of books, very misleading statements, and so on and so forth. The key to Ramapo is you have a town supervisor for which now there are civil penalties enacted, civil monetary penalties, and that supervisor was permanently enjoined from taking part in municipal offerings, i.e. fairly difficult for that individual to be finding employment in the municipal world ever again. So that case, I think, mostly points out that, folks, you are dealing with some serious matters here, and you could be, as an elected official, held personally liable. Again, in the context that person was carrying out fraud, nonetheless, these are all things to be mindful of. Okay, let's jump quickly to 15C212 and the new events. There have been a lot of questions regarding this. There have been a number of presentations. The SEC was supposed to take part in a presentation several weeks ago. At the time, they did not, because we were in that phase of federal government shutdown. So the SEC hasn't really verbally spoken. I would submit to you that when you read the release, and it's about a 160-page release with footnotes regarding event numbers 15 and 16, I think the SEC has spoken. I think the SEC has spoken all they're going to speak with regard to some of the very key esoteric aspects of this, and that first one is materiality. So there have been a number of folks in questions to some of the regulatory bodies. Are you going to tell us what's material? Is the SEC going to tell us what's material? I think the answer to that is no. They're not going to tell us what is material in terms of some bright line test. They're not going to tell us if you're going to enter a financial obligation that obligates you to $1 million contractually, City X, that in and of itself is material. This is a facts and circumstances decision. This is going back to those definitions we talked about earlier that result from 10b-5 analysis. This is looking at the totality of the circumstances. This is really for, I would submit, the lawyers who deal with securities matters to be determining and advising all you folks on, do we think this is material? I think part of this materiality exercise as well, it should not be viewed in just simply, is one document material. So by way of example, if an entity has entered into, let's refer to it as an economic development rebate, TIF rebate type of agreement for X amount of money, might that document in and of itself be material? Perhaps not. What if that entity has entered into 10, 20, 100, 130 of those types of arrangements, all basically operating the same? Might those obligations in the aggregate be material? Probably. So I think there's a whole host of factors that will have to be analyzed to determine if you incur a financial obligation, is it material? The second part of this you see on the screen that's highlighted is financial obligation. Let me just quickly go to the next slide. So what is a financial obligation? It is defined by Rule 15C212. It is a debt obligation, a derivative instrument entered into in connection with or pledged as a security or source of payment for an existing or planned debt obligation, or a guarantee of either one or two. So breaking this down, now you start to look at, well, what is a debt obligation? Again, here I would submit this might become very parochial. I think folks will have to take a look at certain state law. There would be certain types of instruments that under state law, counsel might quickly surmise are debt obligations. There might be situations in one state we might not say that a debt obligation is in state A, we'll say Iowa is we think is debt. Maybe in Wisconsin, under their state law, we might say something is debt. let me just give you some examples here, and I don't want to presume to be telling you these are or they aren't, but these are the examples that we've seen and that I think we'll all be working with here in the near future. So, as I stated earlier, TIF rebate agreements. Is that a debt obligation? I would submit in State X it very well might clearly be a debt obligation. In State Y it may not be a debt obligation. I think you have to look at the agreement itself to help determine whether you think it's a debt obligation. I think you have to look at the covenants, the full body of that TIF rebate agreement to help determine whether it might be a debt obligation, thus a financial obligation for which we'll have to provide a material event notice on EMMA. Interfund transfers. Is an interfund transfer a financial obligation? Well, I think there would be in certain states, under certain state law, where you might say an interfund transfer could be a financial obligation. I think likewise, depending on the circumstances, an interfund transfer may very well not be deemed to be a debt obligation. I throw those out as examples. I'm sure we can all think of any other numerous kinds of financial obligations. I think in broad context, we're not generally talking here about operational types of contracts. So, for instance, I'll raise, what about the purchase of copiers? Well, by way of example, if an entity is going to enter into a lease for 1 or 2 or 3 copiers, do I think that rises to the level of debt obligation and isn't other than just normal operations? I think a couple copiers that you'd normally be leasing, it does not rise to the level of debt, does not rise to the level of financial obligation. However, if some entity thought there was going to be some major breakthrough or some major reason and there was going to be a run on copiers and they went out and entered into a contract to purchase 1,000 copiers with the thought they were going to turn those copiers and make a profit, that might start to look like a financial obligation for which we'd say now the circumstances are dramatically changed. So that's kind of a wacky, goofy scenario, I grant you, but I say that in terms of just trying to give you some context that a financial obligation broken down into its component parts to determine whether we're going to be needing to disclose it. It's very much of facts and circumstances, looking at the totality of the mix, again, going back to materiality to some extent that we're just going to have to analyze. You see there what a financial obligation does not include, no additional rule with regard to analyzing financial obligation if it's a security for which there's an official statement and that official statement is being provided to the MSRB consistent with Rule 15C212. So, next slide, you can see financial obligation is debt-like. Any obligation that could impact liquidity, creditworthiness, or could impact existing securities holders' rights. So again, this all needs to as well be taken in light of the context for what other outstanding indebtedness might you have. And you see there again, it's not intended to include your run-of-the-mill ordinary financial operating liabilities. So leases specifically were not labeled. Clearly a lease could be, depending on the type of lease, it certainly could be a vehicle that would be used to borrow money and thus clearly something you would need to provide as a material event notice on EMMA. Again, a simple lease for just a copier, no, that's operational and would not need to be disclosed. There are a number of guideposts for debt obligations. I think I've alluded to. We'll be looking at state law. I think to some extent, although I do think there will be a disconnect, we'll be looking at audited financials. And again, all of these things I would submit, they're going to be guideposts for how we believe an instrument might be or a contract might be debt obligation or whether it might not be. Derivative instruments, I'm not going to get too in-depth into this. Obviously, to the extent any of the folks on the phone call are entering into swaps, hedges, any of those types of things, I think they'll be getting a very hard look in and of themselves as to their operation to determine whether those need to be included separately under EMMA. Next, guarantees. Of course, guarantees can be a financial obligation to the issuer. For the most part, I think probably guarantees will need to be listed. But again, have to take a look at the instrument itself and how it's operating. Materiality, again, we've talked and alluded to this, but with respect to is the SEC going to provide us more guidance on materiality, I think they've given us all the guidance that they're going to give. All right, that's moving on. How does this now all come into play in a broader context under continuing disclosure? So let me just step back very quickly on both 15 and 16 from a timing matter. So 15, I would articulate that is a complete going forward analysis with regard to contracts once you've entered into and issued a new CDA for which after February 27th for which you're going to have to comply. 16 is a bit of a look back. I think there's been a lot of confusion on this, and I want to put it into context. Let me just go back to Let's just take a quick look at 16 separately. So again, a default, acceleration, termination, modification, or similar event that's number one, a financial obligation, which we've talked about, and number two, reflects financial difficulties. So what the SEC is trying to do, just very briefly here, they want to have investors understand a more total financial situation of an issuer. So 16 is a bit of a look back prior to February 27th. Please do not hear that and say, oh my word, I've got to go back now and take a look at every contract or item that might be a financial obligation for which we've already entered. No, I would submit to you 16, the most important provision in 16 is that it reflects and is caveated by reflecting financial difficulty. So as we go forward, yes, I think there will need to be some general sense of all of your financial obligations as an issuer out there. Do I think that means we have to all go back and in great detail take a look at each and every contract that we think may have been a financial obligation in the past? No, I do not think that, and I don't want anybody to go do that. I think 16 is rooted in reflecting financial difficulty. Let me quickly move on to continuing disclosure and then policies and procedures, because I think this is where a lot of this is going to be reaching into the practical. So, as we move forward now with these new rules, you can see that the SEC through 15C212 has greatly expanded the scope for what are financial obligations and what do you folks need to be thinking of in terms of complying on a continuing basis. It is a fairly short time frame. When these events occur, you still have 10 days in which to file, so we have to be very cognizant of when these events occurred. This is where I think your policies and procedures that hopefully you have in place if you've issued or if you're about to issue, you're putting them in place. And this is where I would submit to tie this all in. With respect to now these new rules, it will be time for all of us to take a look back at your policies and procedures, because you're going to have to, moving forward, you're going to have the underwriters asking you much more deep questions about your ability to comply. I think the manner in which issuers are going to have to do that will be to show that you've updated your policies and procedures. We're going to have to take a hard look at those policies and procedures to make sure that there are people in place at your organization to be monitoring whether you're entering into financial obligations. I think that will all kind of move through almost an organizational chart type analysis to make sure that you're not only complying going forward, but able to monitor if you have a financial distress situation, that you're able to recognize what you might be disclosing in terms of your event notices. I'm going to quickly move through here new bond offerings. I think most people are working through those issues as part of their policies and procedures. Again, I think with respect to continuing disclosure, that's going to be another closer look, as well as to responsibilities as you issue new debt. Let's keep in mind in all of this that this is all the responsibility of the issuer, and that's why we're raising it. Here, I want to focus on now very quickly compliance. Everybody should read through these. Public officials should read through these. The financial staff should read through all of these very closely. I think these are the key 13 points as you work your way through your policies and procedures to be keeping in mind, working with us to make sure we are flushing all the appropriate issues out so that there aren't trip-ups. You can see here one of them, and this I think goes to looking at number 16 and trying to get just a rough outline of financial obligations in place, providing a list of not only your bonds, but what other financial obligations might an issuer have out there, keeping good copies, records, so on and so forth. I think the most difficult aspect of all of this, and hopefully this is where procedures will be able to help you track this, but when you have personnel turnover, I think this becomes very difficult. Please read through those. Those are the things as we work through with you policies and procedures. These are the types of things we're going to be talking about. Annual training, again, another very key component of this for governing bodies and their members. That's what this phone call is supposed to be part of, or this webinar. I would urge everybody to, as you work through your policies and procedures, again, this information be provided to the governing body, as much so they can recognize this is very serious stuff, that they do have a very important role to play, and that ultimately the issuer is liable. I have 2 minutes, and I knew this would happen, so I'm going to quickly touch on takeaways. I would submit to you now with the new rules, the Tower Amendment in a very practical way has been eroded, that I think everybody needs to start viewing their disclosure as a continuum, whether it be from a new offering through continuing disclosure and so on and so forth. We're all going to need to take a look at what we've said in offering documents in the past, what we're going to continue to say, making sure that in this new world order we're maybe taking a much more, again, broad approach I think disclosure now is a never-ending discussion. I don't think you can necessarily view it as we went and issued and now we're going to turn around and walk away. I don't think you can view continuing disclosure as not being tied to your next issuance. I think this is all going to be held together. I think the way it's held together is through due diligence, policies and procedures, and a lot of ongoing discussion with professionals across the board, your MAs, your underwriters, and counsel. I think another takeaway, we're moving into another bit of an expanded new role here, and the best way I think to help people prepare for that is start to give some consideration to these items well before you get to the point that you might be issuing. It certainly does not hurt to be pulling out your policies and procedures now and starting to give some thought, starting to work with us as to how you might be amending those. It is a lot easier to do all of this when you're not in the middle of trying to do all the work for diligence and so on and so forth while you're in the middle of a financing. So I greatly apologize that I did not leave any time for questions. Please feel free to reach out to all of us here at Dorsey, whether that be John Danos, James Smith, Chris Kuhn, Bob Jostin, Dave Claypool, so on and so forth. That's why we're here. Reach out to me. Again, this will be eliciting a lot of discussion as we go forward. There's a lot of nuances to all of this. So please don't hesitate to reach out to us. With that, my time is concluded, and I want to thank everybody for joining us today. Let's all be careful out there. It's a bit of a brave new world, but I think in its totality, nothing to be running to the hills about, just something and a lot of things, again, to try and be viewing disclosure with much more heightened sensitivity and on a lengthy continuum of it's an ongoing matter for which you now need to be really paying attention at a number of different levels. So with that, thank you very much, everyone, and have a good rest of your day and have a nice weekend.